pursue injustice and very serious cases of injustice without fear or favor. The reality is that it has spent the last 12 years proving itself to actually be a deeply dysfunctional court, a court that has been mired in irregularities legally, a court that has been mired in prosecutorial misconduct of a nature that in most Western states the prosecutor would have been disbarred and probably even himself prosecuted for perverting the course of justice. You have also seen manifest evidence that far from being a universal court, as the ICC has actually presented itself as being, this in fact has boiled down to a European Court for Africa. This institution that says it is that claims to be a genuine universal international court is very far from that. It only represents, for example, maybe 1/3 of the world's population. The United States is not a member, Russia is not a member, China is not a member, the world's biggest democracy, India, is not a member, and so on and so forth. It is many things, but it is not the international court that it claims to be. It is at best a very flawed European court for Africa. The ICC has also claimed to be independent, but at the same time, this claim is just so ludicrous because it actually affords its own statute, grants the United Nations Security Council special prosecutorial rights. So the world's most political body, made up of politicians with varying political agendas, has a prosecutorial input into the day-to-day affairs of the ICC. So it's certainly not independent in that sense. This is also a court that actually says it is truly independent. The independence of any court, of course, depends on its funding. The reality is that anywhere between 60 and 66% of the funding of the International Criminal Court comes from the European Union. So this is, in effect, a European Union funded, European Union directed institution that has shown itself to be nothing more than an instrument of European foreign policy. And for those of us who hail from the African continent, the simple fact is the big five funders of the ICC are the big five former colonial powers within Africa. That's to say the United Kingdom, France, Germany, Italy, and Spain. So there is, right from the start, an overwhelming déjà vu that this, in fact, has been claimed to be an instrument of neocolonialism. And in many ways, that case is very, very sound. This is also a case, a court that, as mentioned, has had a history, a continuing history of dysfunctionality. You have had examples within the court where the chief prosecutor, for example, has actually tried to hide hundreds of items of exculpatory evidence. That's to say, evidence that might have proved the innocence of a defendant. Hide this evidence not just from the defense, but also from the judges on the ICC bench. You have had cases where judges at the ICC have tried to introduce new charges halfway through a court case, a very serious court case. This again is just sort of so unlike any established legal practice that it is in fact almost unrecognizable. This is a court that also tries to present itself as dealing with some of the most serious and intricate allegations of war crimes or crimes against humanity or genocide that the world has ever faced. And yet it has appointed as full ICC judges, judges who have never been lawyers, let alone judges in their career. And in some cases, their only qualification is that they spoke English. So even the most junior rural magistrate in this great country of South Africa is better qualified to be a full ICC judge than many of the people that are sitting in judgment on Africa today. There is no great surprise, therefore, that the ICC's cases in Kenya, the Kenyatta case, for example, amongst others, have been caught up in scandal after scandal because of ICC misconduct. There's no surprise that the chair of the bench that has actually been trying to examine this issue is herself a Japanese diplomat with no previous experience as a lawyer. So these are just some of the issues which I think have come up from time to time and continue to be at the forefront of Africa's concerns, amongst many other concerns, on this issue. So we have seen a large amount of valuable African Union time wasted in the course of the last 48 hours by and through nothing more than European ICC game playing. Thank you, Mr. Chairman.
Thank you, David. Before we give a chance for questions and comments for your side, let us present. Yeah. Professor Daniel Makasi, the acting chairman for African Union Commission for International Law. The floor for you.
Merci, Monsieur le modérateur, pour la parole. Je tiens d'abord à saluer l'intérêt de médias qui, en réalité, servent de vecteurs et de courroies de communication avec les opinions publiques nationales, continentales et internationales. Et l'intérêt est partagé sur cette question. Mais il est très important de souligner ici que le temps du droit diffère du temps du journalisme. Le droit ne doit pas être traité avec un esprit de sensation, avec un esprit de précipitation, avec un esprit d'instantané. Le droit et la justice sont des institutions tellement importantes qu'il faut éviter de le traiter avec un esprit purement journalistique. Je suis persuadé que les journalistes qui vont traiter de cette question puissent tenir au minimum compte de principes de droit, des instruments de droit. Sinon, ça sera de la spéculation. Je sais qu'il y a des journalistes économistes, je sais qu'il y a des journalistes internationalistes, mais je sais que ça doit être difficile de trouver facilement des journalistes juristes. Cependant, je vous interpelle à ce que dans vos articles, vous puissiez vous référer au texte juridique, parce que là, vous traitez une affaire internationale juridique. Ceci dit, je tiens à souligner quelques éléments essentiels. Dans la pratique des États, depuis la nuit de temps, les immunités diplomatiques ont été acceptées et sont devenues même une coutume internationale. Et pour cela, il n'y a pas seulement des conventions internationales, mais il y a même la jurisprudence internationale qui consacre l'inviolabilité des officiels. Il est vrai qu'à la suite du statut de Rome, il y a eu une évolution. Mais cette évolution ne porte pas encore atteinte de manière effective à cette tradition des immunités diplomatiques, fondement même du droit international. Il est évident que dans le statut de Rome, on évoque la non-pertinence de la fonction officielle. Mais là, c'est en termes conventionnels. Par la suite, ici, il est question plus de se concentrer sur la poursuite et la compétence. Donc, il y a des doctrines, il y a des principes de manière générale, mais par la suite, il y a des questions de procédure, il y a des questions de compétence, il y a des questions de poursuite. Pour ce qui est de poursuite et de compétence, là, nous sommes en droit international pénal. Nous avons quitté le droit international général. Le droit international général consacre les immunités. la jurisprudence aussi consacre les immunités. Je peux vous renvoyer à bien des arrêts de la Cour internationale de justice, mais je ne me trouve pas devant un auditoire de juristes, mais je tiens à souligner l'essentiel qui peut être retenu. Donc les immunités est une coutume internationale qui ne se discute pas, malgré la non-pertinence de la fonction officielle inaugurée par le statut de Rome. Deuxième élément, il y a le droit international pénal qui vient en évolution. C'est-à-dire, nous avons désormais des conventions qui consacrent les infractions, les crimes internationaux. Mais là aussi, il faut noter qu'il y a des principes et des règles. Je m'en vais seulement vous évoquer ici le fait que par désaccord, on peut bloquer l'arrestation d'une personne poursuivie dans le cadre du statut de Rome. Le statut de Rome